So today we can discuss a new topic, that is dissolution of a firm. So we all know that what's a partnership, what is a firm, etc. So partnership is an agreement between the partners to carry on a business for profit and to carry on the business either by all the partners together or any of the partner for all of them. So this is partnership, and the partnership is collectively known as partnership firm. So now we can look into how the firm, we have already discussed the what are the rights and duties of the partners. So now we can look into the how or what are the modes of dissolution of a firm. Dissolution means coming to an end of the partnership. So it is stated under section 39 of the Indian Partnership Act of 1932 that dissolution of a firm, that is dissolution of a partnership between all the partners of a firm, is called the dissolution of a firm. So that is between all the partners. It is a dissolution of the partnership between all the partners is called dissolution of a firm. So there are different modes or different kinds of dissolution by which a firm can be dissolved. So first one is by consent. Then next one is by agreement. Then the third one is by compulsory dissolution. Then next one is contingent dissolution, dissolution of firm at will by notice, then dissolution by court. So these are the 6 modes of dissolution by which a partnership firm can be come to an end or can be dissolved. So first of all, we can look into what is partnership dissolution of partnership by consent. So this is stated under section 40. So I will read out the section 40, that is dissolution by agreement. A firm may be dissolved with consent of all the partners or in accordance with a contract between the partners. So there are 2 modes are stated under section 40, that is either by consent between the partners or between a contract between the partners, that is by agreement also. So a dissolution of the firm can be either by consent or by agreement between the partners. If there is a contract to the contrary, that is if there is an agreement to the contrary, then it can be dissolved in such a way. Otherwise, with the consent of all the partners, if they decide that we will end the partnership firm from this day, that is from if July 20 onwards, then the partnership will come to an end because it is with the consent of all the parties. Okay. So next mode of dissolution is compulsory dissolution. It is stated under section 41. Compulsory dissolution. So the first clause is omitted by Insolvency and Bankruptcy Code. There are 2 modes under section 41 earlier. Before the Insolvency IBC Code of 2016, there was first ground was insolvency of any of the partner, and second one was by happening of an event which makes it unlawful for the business of the firms to be carried on or for the partners to carry it on in partnership, provided that where more than one separate adventure or undertaking is carried on by the firm, the illegality of one or more shall or not of itself cause the dissolution of the firm in respect of its lawful adventures and undertakings. Okay, so this can happen in 2 ways, that is compulsory dissolution can happen either by insolvency of the partners or by illegality of the business. So how can this illegality of business happen? It does not happen from the inception of a firm. That is, if the business is illegal from the inception of a firm, it is hit by the section 23 of the Indian Contract Act. That is, it is hit by public policy. So it is void contract or void partnership from the beginning. But what happens in this section 41 dissolution is that at the starting of the business of the firm, it was a legal business, but when the business was going on, either due to some changes made by the legislation or due to some other reasons, the particular business become illegal. So in that case, there will be a compulsory dissolution by virtue of section 41. So by virtue of IBC Code of 2016, only the insolvency of the partner was removed from section 41. So now illegality of business is only there under section 41. Then next mode is contingent dissolution. It is stated under section 42. So dissolution on the happening of certain contingencies. There are certain contingencies on the happening of which the partnership will be dissolved. Subject to contract between the partners, a firm is dissolved A, if constituted for a fixed term by the expiry of that term. B, if constituted to carry out one or more adventures or undertakings by the completion thereof. C, by death of a partner, and D, by the adjudication of a partner as insolvent. So there are 4 modes under section 42. Okay. First one is expiry of time. If a particular time is fixed, after the expiry of the time, the partnership will come to an end. But if there is a consent of the partners to carry on the business, then the partnership will continue. It will not be expired. It will not be dissolved by the expiry of time. Next one is completion of business. If the partnership was set up for a particular business, then it will be dissolved after the completion of that particular business. Then death of the partner. Once there is an agreement between the partners, or there is a agreement or contract between the partners that the particular agreement will be particular partnership will be dissolved by the death of one of the partner, then the partnership will be dissolved by the death of the partner. If there is an agreement that the partnership will continue with the legal heirs of the partnership, then partners, then the partnership will continue. Okay. The last point of dissolution under section 42 is insolvency of partner. That is, once the partner, any of the partners declared insolvent by a court of law, then the partnership can be dissolved. Next mode of dissolution is dissolution of firm at will by notice. So we know that there are different kinds of firms. So in case of a firm at will, that is with the consent of the parties, it is constituted. Then how the dissolution happens? It is stated under section 43. That is, where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all other partners of his intention to dissolve the firm. The firm is dissolved as from the date mentioned in the notice as the date of dissolution, or if no date is so mentioned, as from the date of communication of the notice. So by giving a notice in writing, the dissolution of a partnership at will can be dissolved, and the date is if the notice does not specify any date, then from the date on which the communication of notice happens. Otherwise, the date of the notice is the date of dissolution of the firm. Last method by which the firm can be dissolved is dissolution by court. This is stated under section 44. So under section 44, there are various grounds. That is, insanity of a partner is a ground. Then next one is permanent incapacity. That is, if the partner is permanently incapacitated either by any accident or by any disease, then it will also act as a mode of dissolution, ground for dissolution by court. Next one is by persistent breach of agreement. That is, there is an agreement between the partners and one of the partner continuously breached the agreement between the partners between the partners in the partnership firm. Then this is also a ground for the other partners to approach the court for a suit for dissolution of the firm. Then next one is transfer of interest. If there is a transfer of interest, or there is a perpetual loss happening to the firm, or there is any other just and equitable ground is there for the dissolution of the firm. This can happen only when a suit is moved by any of the partner to the court for the dissolution of a firm. So dissolution of a firm by court under section 44 is only when there is a suit by a partner. So these are the various modes by which a partnership can be dissolved. Okay, so hope all of you understand the dissolution of a firm. Thank you.